Good day, good day. Thank you all for coming in. Today's February 4th, 2023. Got a lot of information to uncover today. Thanks again for coming in. I'm just going to allow another 5 minutes. We still have people joining us. We're going to go over a lot of information today and still have time to get into your questions. All right. Before I allow you to raise your hand to ask a question, please always remember to state your name, the tier that you are in, whether that be freshman, sophomore, junior, or senior. So that way everybody here knows what you have studied and the overall intent behind the nature of your question. All right. Got a few more people coming in. All right, let me start off with some announcements. I got two for you. The first one is going to be, this is going out to our private client list, those that are private clients. And, you private clients, you guys are already under an agreement with us. So all of you have your monthly one-on-one with your reps to go over your assignments and to see exactly where everything is once per month. That's a good thing, but you will also be able to join me and our executive assistant, Nancy, all right, somewhere around the 15th of every month. I haven't decided if it's going to be the exact 15th or somewhere around there. We're going to have what's called a power call. All right. And this is your mandatory, but I mean, this is not mandatory, but you're welcome to come in and use that opportunity to share your thoughts and develop a game plan for your unique endeavors. Okay. So right around the 15th, we'll be doing another call with all of the private clients to come in and kind of brainstorm and see what's going on. Okay. Second thing, calling the IRS. Now, when you join, whether that's the complete tier or the freshman tier, you're immediately introduced with the introduction of the trust, what it is, how you're going to use it, the parties in the trust, and starting the process with conducting your Internal Revenue Service interview to call the IRS and get your 98 number to first establish that existence with them on the zero file list, right? So our main guy who calls, some of you have hired us to do that for you. Our main guy that calls, he has discovered some new tactics to slow up the numbers of 98 EINs that they're giving out. So what's happening is they told him to confirm the country, to confirm the continent. Where's the country from? And he's used Amsterdam, he's used Colombia, just as we showed inside of the course. And their response is, well, we can't find Colombia in South America, and they hung up on him. So these are the things that we find pretty hilarious. It shows that they understand we're catching on to these tactics that the 1%ers have always lived by. And now we're doing it. And these are the rules and laws that our forefathers and foremothers have gone by and done. Now we're knowing how to do this. So this is exactly what you're going to do. Just make sure to understand when you're making the call that you be prepared to give them the continent if they ask you which continent is your country on, right? It may not happen all the time, but just be aware of that. Okay. Now we're going to get into a few of your questions that I've received within Patreon messages. One, we're going to go into the actual non-UCC. There's two. You guys understand there's two. Maybe there's three, depending on your unique situation. I say three because you may have children. And I'm going to get into showing you how to use the non-UCC when it comes to your children that are under 18. But first, you all have access to the information in freshman and sophomore, and it shows you how to fill out that non-UCC form. So I'm going to share my screen here, and we're going to go over how to do that for yourself and also for your property. We must convey our property. okay? So as you see here, this is the non-UCC form, otherwise known as a UCC financing statement. That's the general term of this form. UCC financing statement. All right, it's used to properly identify creditors and debtors when it comes to actual promissory notes. Someone is given valuable consideration and the debtor promises to pay back on that valuable consideration. So you have to do this when it comes to your, should I say, when it comes to taking all of your estate and gifting it over to the trust. So therefore you continuously pledge allegiance to the trust and no one else. This is how tax avoidance works. In this example, let's say we have Luke Skywalker, right? Box 1A is first, middle, last name in this format. This is the estate format. Luke Saber, family of Skywalker estate. And let's say Luke was born in Beverly Hills, such as me, and I have to utilize the county address where that birth certificate came from. And that's going to be 12400 Imperial Highway, Norwalk, California, 90650. Okay. And box 2, it's the same information, but now we're doing the other side of the coin. Box 1, let's say that was heads. Box 2 is going to be tails, right? There's two sides to this ledger here. There's a public side and there's a private side. Box 1 is the private side. Box 2 is the public side. And that's going to be last name first, then the first name. That's it. There's no space for additional middle names or anything like that. Again, the address is the same. Number 3 is the secured party, aka the lender. Now this is on the flat edge of the coin that controls both the public and the private. All of the assets are gifted to this entity right here. Okay. That's going to be Old Republic Express Trust, whatever your trust is named. And then you're going to use the foreign address. The foreign address that you've given the IRS to establish your trust as a foreign trust in another country. You can state whichever address or location you want to establish your trust. Most of these things are done through Zoom calls with all of the parties anyway, so the host can determine where that's going to be. Box 4, I'm going to type out exactly what goes in the collateral. Here we go. It is all property, whether tangible or intangible, and all in property real. Now that is a special lawful term there, or real property. One second. Didn't want my dog to go ahead and interrupt. He starts to bark at the door. All right. So in property real and real property, two different things. In property real means everything that is below the earth where your property is located. This is going down at least 500 feet below, and you're claiming all of the rights, all of the minerals, everything that is at least 500 feet below. Real property is everything above. This is the rule: as above, so below. Located in the Republic of, and you're going to put your state, which would be dark side, right? Or any other state. Sometimes you may have more than one property in different states. Now or in future, to be held in trust, in fee simple. Some of you may remember the term allodial title. Well, fee simple is what they call that today. Per, I'm going to say literary trustee minutes on the scheduled books titled Other Property Exchange, non-real estate assets, right? Or it's going to be called real property assets. Okay, so that's how you're going to start the collateral there. You don't need to say anything out there that you've seen on the script, all of the other stuff where it's talking about, you know, all of the language that you find out there with the secured party creditor stuff. You don't want to do that. Again, your certificate of estate title, this is the authenticated birth certificate. Once it comes back from the Department of State, there's a number at the top that goes there. You can put the date that the U.S. Secretary of State gave you, followed by the equity secured promissory note. Please put the exhibit number, followed by the legal description of real property or parcel number. So you can do either or. Now, when that's done, you will select held in trust. Everything stated in this collateral is held in trust. 6A, this is a public finance transaction because your entities, as far as the debtor in box 1 and box 2, whether public or private, are operating within the public and they're utilizing finance transactions, commercial transactions. Make no mistake, this is not a transmitting utility. That is for actual utility companies. Okay. 6B, this is where you turn the entire UCC1 into an actual organic public lien by selecting non-UCC right here. This is actually how banks are supposed to reference your mortgage. They have to file this form and attach your promissory note down in the county, but they never do. We all know why. All right, now let's say you are trying to do a proper process for your house, to put the house in property or in trust. Whichever name is listed on the promissory note is going to be listed in box 1A and 2B. 3 is going to be your trust as well. Same address, same collateral information. Now you're going to have to create a promissory note for the trust taking on the property. 1 second, let me allow additional people to come in. Looks fine. All right, so you're going to have to create another promissory note. So the first one was for the public finance transaction. That's for everything in your life estate. And the second one is going to be for your property. You can use the exact same formatting of the promissory note that you already have. Just emulate and copy over the information that you have with your bank. Just remove the bank's name and use the trust. It has to mirror. Same pricing, same interest, whatever. You are now promising to pay the trust that very same information that's on the mortgage. Okay, and then you would list that exhibit number here for the property. Record both items down in the county. And the only thing that you change here, you're going to deselect public finance transaction and you will select manufactured home transaction. To get more information on this, go to UCC definitions and you'll see what that is. Other than that, everything else stays the same. Okay. So that's for your life estate, your social, and the other one is for your home. And of course, you have to do a quitclaim deed where you are the grantor and the trust is the grantee, okay? When you list your valuable consideration in that quitclaim deed, make it $21, but nothing more than $100. And you should be fine with that. All right, so now, went over that. Before we get into questions, I wanted to go over what I think is very, very unique. And my team and I, we had recently had a discussion with our very own Julius, and he's doing very great things when it comes to discharging debt, but he's also introduced us to different schools of thoughts when it comes to looking at additional laws and regulations as far as what you can do when it comes to acquiring mortgages or auto loans. I see these methods as something that can be paired up with what we've been learning here in this course. You guys have all seen, and if you haven't, go and look at the accord and satisfaction information. Whereas it is a breach of contract. If you have an existing loan and you make payments, well, you simply just submit a dispute first, followed by sending in money orders or checks with the word accord and satisfaction on the face, and on the back, you have specific language there. If they cash it and they don't refund it to you within 90 days, the entire obligation is closed. And sometimes they close it, sometimes they don't, and you have to enforce it by suing them, right? Now, in addition to that, I wanted to look into some other laws that was brought to our attention that we think can be coupled together. I think if you make a full circle, where you cut them off at every angle, it's really hard for them to walk away and still win. Okay, so let's look at a few. This is an actual court case dealing with Title 15. This court case is dealing with Catherine McComie Gray versus Bank of America and Countrywide. She is suing them. She's attempting to, well, she was looking at all of her paperwork when she got the house back with Countrywide before it was transferred over to Bank of America. And with Countrywide, she found that there were missing documentation that she was supposed to have when it comes to proper disclosures, such as rescission forms. They didn't give her the proper rescission forms just in case she decided she wanted to back out of this loan, and she has the opportunity to fill out those forms, turn it in by midnight of the third business day from the date that the loan began. From there, they are supposed to refund her all of the money that she's put down, and within 20 days, come and get the property, whether that's an auto loan or whether that's the house. Someone from the bank has to come and get the keys within 20 days. If they don't, she's supposed to receive the title, she can keep the asset, and she still gets the money. Right? That's what the law says. It's Title 15 USC 1635. I'm going to take a look at it. It's called the right of rescission as to certain transactions. I'm going to go over this quickly, and then we'll get into the other information that I'm talking about. So this is the disclosure of an obligor's right to rescind. Okay. It says, except as otherwise provided in this section, in the case of any consumer credit transaction, including opening or increasing the credit limit for an open-end credit plan in which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any property which is used as the principal dwelling of the person to whom credit is extended, the obligor shall have the right to rescind the transaction until midnight of the third business day following the consummation of the transaction or the delivery of the information and rescission forms required under this section together with a statement containing the material disclosures required under this subchapter, whichever is later by notifying the creditor in accordance with regulations of the Bureau. Now, the Bureau is the CFPB, Consumer Finance Protection Bureau. Of his intention to do so, the creditor shall clearly and conspicuously disclose, in accordance with regulations of the Bureau, to any obligor in a transaction subject to this section, the rights of the obligor under this section. The creditor shall also provide, in accordance with regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind any transaction. Now, B, this is return of money or property following rescission. When an obligor, that's you, exercises his right to rescind under subsection A, he is not liable for any finance or other charge, and any security interest given by the obligor, including any such interest arising by operation of law, it becomes void upon such a rescission. Within 20 days after receipt of a notice of rescission, the creditor shall return to the obligor any money or property given as an earnest money, down payment, or otherwise, and shall take any action necessary or appropriate to reflect the termination of any security interest created under the transaction. They have 20 days, right? For the sake of time, let me go down. Now, here are exempt transactions. This section does not apply to a residential mortgage transaction as defined in section 602W. Stop right there. Now we're thinking, wait a minute, we can't do this with the mortgage. It just says, no. Under this section, you're going to find there are residential mortgages that you acquire as federal government loans, and there are other residential mortgages that are considered private lender loans. If you're dealing with a private lender, this will not work. This only works if you used your credit of the straw man, of the ens legis, because they were already paid. And this is dealing with what's called an insurance transaction, an insurance contract. Everything with mortgages or auto loans, any financial transaction where you are using your social security number, it is an insurance obligation. Your social security number is old age insurance. When you look at the Articles of Confederation, you find that Canada is a part of the Confederacy as well. Canada is an extension of the United States. They use what's called SIN numbers, social insurance numbers. It's the very same thing, right? So do not let them fool you that you cannot do this with a mortgage. You can if you used a bank. All right. Time limit for exercise. Now, there is a time limit. To be very short and quick, you have within 3 years to ask and cancel your mortgage. So that's if you're within 3 years. If you are past 3 years, right, you got your mortgage 10 years ago, let's say, or 4 years ago, or 3 years and 1 month ago, go ahead and refinance. Refinance, pull the money out. The clock starts over. Now you can do this. With this process, I would include the accord and satisfaction. I would. Every payment that you pay after the notice has been given, that's considered under duress. So when it's time for you to sue for an accord and satisfaction, and they say, well, your accord and satisfaction is only subject, it's only subject to a bona fide dispute. Well, your notice for rescission is a valid bona fide dispute. And they didn't give you any of your money back or notice of cancellation within that 20 days, as the law says they're supposed to do. When you go back and read this case, you will find that she lost because She didn't do an accord of satisfaction, and she didn't refinance after the 3 years, but she decided to rescind this entire thing once her 3-year limitations were expired. Now, she made a good argument, but she ended up losing because of that 3-year rule. So you want to reset the clock if you are over that 3 years. Okay. Now, let's go ahead and look at what are you supposed to do when it comes to getting a loan. Let's say tomorrow is closing day. Let's say tomorrow you want to get a truck, right? I'm about to do this myself, about to try and go get this Tesla. We'll see how that works out. I'm going to try it. Now, with this method, it's all about reassigning these notes directly back to the United States, because Federal Reserve notes, mortgages, auto loans, personal loans, all of those that require a social security number, it's an insurance contract. It's an insurance agreement where it goes into a pool of investors who put their money together in sync with what the Treasury is doing. So with a mortgage, I fill out a 1003 application, or with the car loan, I fill out an installment sales agreement application with my social. And guess what? If I'm going to Tesla dealership, or if I'm going to an escrow servicing or mortgage servicing company, they are the third party who's going to give it. They act like a broker, and they're going to give it to the Treasury window. That's where the money is going to come from. It's going to route itself all the way back to the bank. Then the money is going to be routed to, quotation marks, the seller. But what came back was probably 10 times the amount of whatever is on that note that you're asking to be financed for. The face value comes to the seller, but I would say 90% of the rest is staying with the bank in the form of credits. That's the deal that they get for taking on the transaction, because the banks cannot issue their own credit or capital to you. That's a rule that would violate the National Currency Act, the National Banking Act of 1863. So they can't do that. So therefore, you're funding this thing. Now look at it when it comes to a cycle. Here you are giving your piece of paper, that's money. It goes to the Treasury. What comes back is obligations of the United States. And now it's coming back to you to finalize. Okay, so when you look at it that way, you have to know these notes and these auto loans are, it's bonded and it's insured. They are insured notes. When it comes to bonding an insured note, there are 3 parties. There is the principal, there is the obligor, and there is the surety. You are the principal, the obligor is the seller, and the surety is the United States. 12 USC 411 says that all of these notes that are circulating are obligations of the United States. So when you, the principal, sign the note without sending it back, you then become the surety of the debt, paying the monthly premiums every month, which is considered insurance payments. That's what you're paying every month, insurance payments. I don't care if it says that you are the owner of the house. They're calling home ownership. They're calling premium payments home ownership. That's called tenancy in commons. So you have to remove that. The only way you can remove that is by reassigning the debt at the closing table back to the United States. So take a look at, we're going to look at 7 CFR 1901.508. This is servicing of insured notes outstanding with investors, right? So when you come to that closing table, you now have to think, this is an insured note. It is an obligation of the United States. I must get rid of it. This is my job. This is my duty at this point. Otherwise, I will be held as the principal and the surety for something that belongs to the United States. Okay, keep that in mind when you're signing these things. Go down. Let's see, here we go. Section C, assignment of insured notes for rural development, right? We've heard of the USDA, Department of Agriculture, FHA loans. All of that is under rural development. Number one, assignment at the request of the holder. For assignment of an insured note to rural development during the option period at the request of the holder, the following procedure will apply. Now, the option period is the first 90 days when they're establishing your loan. You know how they always tell you, you don't have to make your first payment until 90 days has passed? This is called the option period. This is where these notes here are being processed. Look at I. The holder, which is you at the closing table, the holder will endorse the insured note as follows: pay to the order of the United States of America without recourse. That's what you're supposed to put on the back of the note. Just like anybody would, if you send in a money order or a check to a bank, they're going to fill it out on the back, pay to the order of the United States or pay to the order of Bank of America. That's what they're going to do. You have to do the same thing because your mortgage or your auto loan, your installment sales agreement is a check. Send the obligation back. So here's what you would say. On the front, the salesperson or the escrow agent would tell you, signed by this X here, 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 30 pages, right? Right above that line where you sign your name, you're going to say, accepted for honor. And then you sign your name below, regular. That's it. Accepted for honor. What is accepted for honor? That's a legal term. Right here, accepted for honor. It is one who accepts a protested bill of exchange on which he or she is not already liable for the honor of some party to the bill, the acceptor being liable to the holder and all parties subsequent to the one for whose honor he or she accepts. You see, if you don't do this, you then become the surety. So you're saying you accept it as the principal. Now you're giving it back to the one it belongs to, which is the United States, right? So you have to sign, accept it for honor, and then sign your name. On that same page, flip it over, and this is where you write, pay to the order of the United States of America without recourse. All right, that's page 1. Go to page 2, accept it for honor, and then you sign. Flip it over, pay to the order of the United States of America without recourse. Now, you make sure at the dealership or at the closing table that you get a copy front and back from the escrow agent. Now you know they're probably not going to like what you're doing. They cannot rip up a document like this. They can't shred it and say, start over. We can't accept this. They can't do that. That's a federal crime. So you can just simply tell them, this is what I've been instructed to do. I'm not an attorney. Maybe you need to seek one for yourself before you start risking your licenses. So just give me my copy so I can be out of here. That's what I would do. That's what I'm going to do. Okay. Now, where is this all coming from? This is really coming from Trading with the Enemy Act. Trading with the Enemy Act. And that's been codified in Title 50 USC. Okay. If I were to go to the Trading with the Enemy Act, I want you to read something. I want you to go to section 7, 7E. And this will be it before we start taking questions. Go to 7. Now 7 is dealing with list of enemies or allies of enemies. You know that every U.S. citizen is considered to be a stockholder in the United States corporation. Below that, they are a stockholder of the state that they were born in. All stockholders are considered enemies of the state under emergency powers, right? If you check out the recent video that we talked about, I went over the emergency powers, how we've been in that since 1933. There's at least 4 of them that we're in. And because of this, the president has control over all American citizens, and he's calling them enemies of the state. So that's how he is putting all this debt back on the people, but we still have the power to turn the debt back over to them where it belongs. So if you go down to 7E, I'll read this for you right here. It says, no person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the president under the authority of this act. Any payment, conveyance, transfer, assignment, or delivery of money or property made to the alien property custodian hereunder shall be a full acquittance and discharge for all purposes of the obligation of the person making the same to the extent of the same. Do you see that? So let me go back. Let me go back to when you're signing the documents. On the front, where they tell you to sign, go ahead, put accepted for honor, and then you put TWEA, which is Trading with the Enemy Act, 7E, and also 8A, and then you sign. Flip it over, pay to the order of the United States of America without recourse, go to the next page. You want to make sure you mention TWEA, 7E, and also 8A. Here's 8A. Any person not an enemy or ally of enemy holding a lawful mortgage, pledge, or lien, or other right in the nature of security and property of an enemy or ally of enemy, which, by law or by the terms of the instrument creating such mortgage, pledge, or lien, or right, may be disposed of on notice or presentation or demand, and any person not an enemy or ally of enemy who is a party to any lawful contract with an enemy or ally of enemy, the terms of which provide for a termination. All right. These links will be in Patreon as we upload it, so you can continue reading further to have full understanding. But I wanted to share that with you, and thank you, Julius, for sharing that information with us, my team. And we will continue to expand on that as we are always trying to do better when it comes to different processes. There's more than one way to skin a cat, as I always say. So with that being said, I'm going to stop it right there. Now you may raise your hand for questions if you have any. All right. My favorite guy right now, we're going to Julius. Please unmute your mic, say what tier you're in, and you are live to answer your question. How you doing, Julius?
I'm good. How are you? Good afternoon.
Thank you.
Yes, sir. I've got a question regarding discharging of mortgages. I'm currently on a program with the government. I'm not sure if anybody was aware. They did a mortgage assistance last year, and I applied, which I was approved. The 25,000, whatever they give to homeowners, if you owe any back mortgages, they pay it off, and they pay 6 months of your next mortgage. They pay it off too, of them. They help you pay it off. Now, I'm still in the program, which I have to resume paying my mortgage in May. Can I start the discharge progress before then, or do I have to wait for when the program is done, then I can just start sending them the checks? Or what would you suggest?
I would suggest knowing full nature that they've already been paid before you even got the keys to the property. So yes, start the process now. You don't have to go off of the terms of that agreement, saying 6 months, and then, maybe you can refinance after that. Don't worry about that.
Okay.
Yeah.
Because my 3 years on this house comes to an end. I closed August 2020, which those 3 years start of limitation is coming to an end. So I'm just like trying to get a discharge before
Right.
that.
Well, at least get your notice of signature sent out before that 3 years takes place. So that will start your clock. At least you do that before the 3 years is expired. And from there, you can, I guess for you, since you're not at the closing table, you would have to do a court of satisfaction. You would have to do the treasury gift checks. You know how to do that. And, try them all at the same time.
Okay, no problem. Thank you.
You're welcome. You're welcome. All right. My assistant is telling me to pick on Mr. Jason Smith. If you are here, you had a question, where are you? Go ahead and unmute your mic if you're good, if you're here. Jason Smith. J. Smith. No, not here yet. Okay. All right, going to Flex. You are unmuted.
Hello, hello.
Hey there.
What's going on, Avery? So real quick, a few questions. What could I do about jury duty? I just got summoned for jury duty out of nowhere. I was curious to how to attack that. And also, how do I deal with the Georgia Secretary of State when they're not accepting my DBAs when doing my articles of reorganization?
Okay, so first question was the jury. Simply utilize your Georgia Bill of Rights to shut that down. Okay.
Okay.
Can't remember exactly which sections of it that you want to use. Well, it's more so the religious rights that you have, and that you don't want to be a part of their charter.
Okay.
So just send it directly to the court, clerk of court, and then CC any other party who's accepting your acceptance to jury duty. You want to send it to at least 2 parties.
Okay.
Okay. Also, the reason why you're getting that is because of the information that's down at the DMV. So you got to take yourself off of the voting. And if you're listed as a donor.
I opted out of all that. That's what was confusing me. I had opted out of all that.
Oh, wow. They're still pulling you guys through. Okay. So good. Just send it directly to the clerk of court and whoever is listed on that jury duty summons.
Okay.
Okay. Second part, the Secretary of State, if they are not accepting your amendment to your LLC or corporation, right?
Correct. They're saying that they don't want me to use the word DBA and all that stuff.
Okay. In Telegram, did you see Coach Joe, how he did his affidavits?
When he just put everything all in one.
Yep.
But he filed that with the county, right?
Yep. File it at the county.
Yeah, all my DBAs are filed at the county, but I was told, I guess in the instructions in the class, it was saying that I needed to update everything as far as my LLC with the Secretary of State as well.
On that level, all you're going to do is update the articles. So if you have an LLC, you're going to make your trust listed as the sole member, and you can list yourself as the manager. That's all you got to do.
Got you. Okay, I see. So
yes, they should have a restated article forms or something to that nature, and that's the form that you would use to just to change the sole member. Sole member is the one that makes all the decisions when it comes to the LLC, and it tells the Secretary of State who's responsible for taxation. Just like in your trust, if you had a U.S. person to be the trustee, that's everything that the United States courts needs to know to determine the taxation.
Got you. So I'm just worried about changing the officers. That's it.
Exactly. Yep.
Understood. Thanks, Avery.
You're welcome. All right, Melissa, are you there?
Hello. On the family 98 number for the third trust, we're about to call to get that. Do you suggest having an anonymous name for that as well, or just doing something like the McFarland Family Estate Express Trust?
I would suggest the two of you come together and make up a name that's not connected to the both of you.
Okay. That's what I was figuring, but we had a consultation Thursday with someone and they just said, yeah, just do so anyway, we wanted to verify because they said to do the McFarland, that you could just do that. So, but
you can, but it's not my recommendation.
yeah, okay, perfect. And then I'm a fast talker. So real quick, I just want how to transfer the existing EINs to the enterprise. Do we need to use a W-9 for that or
88,
like from the I'm sorry, from the LLC? Like
8832.
Well, I'm sorry, we did that. We haven't got confirmation of it, but I meant I'm sorry, Chris, help me.
So like the business, like, you know, with the city, with the business license, it has the old EIN, my LLC EIN. How do I transfer that into the new enterprise EIN?
Good question. All right. You can still utilize your existing LLC. After you've submitted that LLC EIN number on your 8832 form, I know you're waiting on the confirmation, but you're still going to need to utilize your LLC in the public domain. When it comes to the monies, you want to deposit that directly into the trust enterprise bank account. Now, this is what the bank is going to need.
We got that.
They're going to need a DBA that shows your trust enterprise is doing business as the LLC name. And they're going to need to see the LLC's articles that says the trust enterprise is a sole member, an additional member. You list yourselves as managers, but list the express trust and the trust enterprise as the members.
Yeah, we've done all that. So I guess we're covered then.
You're covered.
Oh, okay.
All right. Good
Okay,
job.
thank you.
You're welcome. All right. Frenchie, how are you?
Hi, everybody. I'm well, thank you. So I want to piggyback on what you said about the discharge of when you were talking about car loan or that process, or that can apply also for credit card. So if I'm understanding that 3 years that we're talking about, if there is a business credit card that's been over the 3 years, how do we reset the clock for this?
For a credit card, what you're gonna have to do is try to get an extension or an increase.
Yeah, we tapped out on the increase.
Yeah, so then that means the only method for discharge for that is going to be the accord and satisfaction method or the treasury gift check. And I will be showing you
Okay.
shortly in the maybe
Okay.
next week.
Okay, I just want to say for the people who are trying to get the trust to own their businesses. So with the method that you show us, it works for me. So I just got the confirmation that they finally, by giving out the statutes and the copy of what is a person, the definition of a person, it did work this time. So thank you.
Awesome.
Yes.
Thank you for
Thank you.
sharing.
Yes.
Sometimes we just have to show them their own rules, and we get things done that way.
Absolutely. Thank you.
Mhm. All right, we're going to Shubi. Shubi, how are you?
Shalom. I'm doing great. How you doing, Avery?
I'm good, thank you.
I've been going over your courses on Patreon over and over and over, and I'm trying to figure out exactly how to authenticate the birth certificate once I get it back. I think it's the affidavit of ownership.
Mhm.
Is that the form we use to authenticate the birth certificate in the county?
Yes, you do. Yes, just go into Patreon and search affidavit of domicile / claim of ownership. That's the document that you use.
Right, I got that. I got it filled out, but the question I need to ask on that is, do I do it in the county that I live in or the place of birth?
All right. Why don't you tell me the place of birth and tell me where you live?
Okay, place of birth is New York, and I live in Maryland right now.
All right. So on that affidavit, there's 2 sections to list those 2 bits of information.
Okay,
The first line where you're going to give the address, that's going to be the place of birth. I want you to select the address of where you were born, the hospital. Put the address of where you were born.
okay,
Because in that same domain is where the straw man or birth certificate was created. Okay. And then you're going to profess where you are now. I assume you're going to record this affidavit in the same county that you currently live, which is Maryland, right?
correct,
Okay. But the birth certificate came out of New York.
right,
So in the affidavit, you're going to have to select an address within Maryland County that's not where you sleep. And it could be any address.
okay.
That's all you got to do.
Well, I have rental properties, so I could use those or just pick any other address.
Yeah, you can use those.
Okay, because I don't reside there. I'm renting those places.
Nice, nice. That'll work.
Okay, and the other question I have is with the the UCC finance. And I know you went over that earlier and everything is filled out the way you went over it. Does that get filed with the birth certificate or just by itself?
By itself, 1 page by itself.
Okay. All right.
You will not find any counties that allow you to record your authenticated birth certificate with the affidavit of domicile attached to it. It's not going to happen anymore. They're not allowing that. So we have to put all the information in the authenticated birth certificate in your affidavit of domicile. We're merging that and recording that in the county as an affidavit in their affidavit section. The separate transaction is your non-UCC by itself.
So the affidavit of domicile goes with the ownership.
It does. They're one.
Got you. Okay, so everything is filled out properly and notarized. I just wanted to make sure before I start filing that I'm doing it properly.
Yes, you are. Sounds like you are. Yeah.
All right, thank you, sir. Appreciate it.
You're welcome. You're welcome. All right. Going to Samantha. How are you, Samantha? Just got to unmute your mic.
I'm doing well, Avery. Thank you so much for taking my call. I just had a quick question. In terms of accord and satisfaction, what if you're going through a foreclosure? How does that work? Could it be used in a foreclosure?
No, it cannot. Accord and satisfaction works the best when you are in honor, meaning you are the complainant, you're the plaintiff, and you're suing the bank for them breaching your contract. If you're in foreclosure, the best thing that I can suggest is to try and refinance, find a private lender to get you out or pay the arrears as quickly as possible, and put yourself in a better situation to where now you can come and combat the bank.
So, okay, so, well, let me ask you this. So if in an appeal, I would be the plaintiff and now the bank is the defendant, would it work then on appeal? Because there was fraud involved in the mortgage.
Mm-hmm.
So would that work then, or still I would have to go to the previous process you said?
Well, they're suing you right now, right?
No, I'm suing them now. It's in the Supreme Court.
So it's out of
It's
foreclosure?
Pardon me?
Are you out of foreclosure?
No, it's kind of long. It's no. So there was a judgment,
Mhm.
but I'm appealing that judgment
Okay.
in the Supreme Court.
In that appeal, you're still looked upon as the defendant because it's the same
Okay.
case.
Right, okay, that's what I thought, okay. All right, thank you very much.
You're welcome. All right. Jason Smith, you are unmuted. How you doing?
Yes, sir. Good morning, Avery. Thank you so much. This is a great segue and question I have about accord satisfaction. I haven't been through all the videos. I'm just brand new. But on property taxes, so our property taxes on our property, on our home were due for 2022. They were due by February 1st. So it's now accruing, I guess, penalties and late fees since it's a few days after. Would I be now in dishonor, or do they have to sue me before I get in dishonor? If that makes sense.
You would have to be at least 2 years behind to really be dishonor before they decide to do some type of taxing, things like that.
Okay.
So what I would do is, if you wanted to do accord and satisfaction with that, you just have to send out a notice, a bona fide dispute first, and find something that is going to stick. The best thing that I found that's going to stick is when you quit claim your property over to the trust, and that trust is holding a promissory note saying that you're going to pay the trust, let's say, I don't know, more than what you're paying in property taxes.
Okay.
That's an actual viable lien that your trust has over the property. And it has a non-UCC with the quitclaim deed. So you can say, I'm submitting this accord and satisfaction to the county because the trust owns this property, not me. And the county needs to prove to me how they have an actual viable lien where I owe them something, which they can't do. Inside the quitclaim deed, you're not going to be using fiat currency or cash. You're going to use silver dollars or even gold coins as the valuable consideration. That means you're using monies and species. Completely different ball game of money that's being used. It can't be inflated. It can't be tarnished. None of that. And so that will give you a strong argument inside of your bona fide dispute to support your accord and satisfaction to the county. All right, I had to mute you there for the background noise.
Okay, kids, yeah, there's kids. I'm so sorry. So then that leads me to this question. We have not quit claim deed over into the trust yet, and those were property taxes when it was under just my name for 2022. So the trust didn't own it in 2022, if that makes sense.
Right. So that's something that you want to wait on until that's done. But for now, if you have it and you can protect your home from a tax county sale, please do that. County taxes are higher and stronger than a mortgage any day. Okay, you don't want to experience any type of county foreclosures. Yeah, before we start playing around with that, please stay in honor at all times. Once the quitclaim and the promissory note has taken place, then you can start moving forward with accord and satisfaction with your county bills. If the county bill every year, let's say it's $4,000, your accord and satisfaction payment is going to be less than that, of course, at least 10%, right? At least 10%, $400. And you can begin working on it from there. All right, so let's go to Jesus. Jesus, how you doing?
Good. What's up, Avery?
Good. I'm not ditching and dodging. I see what's going on.
No. Don't even say that. Don't even say it. Don't even talk
That
like
was
that.
awesome how you
Don't even talk like, yeah. Guys, can you be quiet? Because I'm in class. Thank you. Shh. Happy Saturday, Avery. Happy Saturday to everybody in the Patreon, whatever. Yeah, so Avery, basically the video I sent you, right?
Yeah.
So there was like 30 seconds prior to that, and I kept asking the officer, I'm like, are we on the record? Are we on the record? Are we on the record? I got him 4 times saying yeah.
Right.
And then, you saw the video, I was popping my stuff. And that's when he wowed out and said, "Oh, the litigant is not subjecting the jurisdiction." And I said, "Correct. The litigant is not subjecting the jurisdiction," and hung the phone up on me. Guys, Soleil, Saya, shh. I'm being serious. So I was told by him to go Monday to the window to get the recording. Now, I like to play worst case scenario. Let's say, for example, that recording is not there because that officer obviously knows that I know something.
Mhm, mhm,
Like I'm trying to play devil's advocate right now. Now I'm trying to go against myself.
mhm.
What's the play?
You don't
Yeah.
need the audio recording at all. What you did do is correct. You first tried to establish jurisdiction before you moved forward, and you may not want to say equity or chancery in New Jersey. So they try to push it and say, well, you're simply neglecting the jurisdiction that we do have right now, which is at law or abuse and neglect courts. That's the one that they have you in. You said no to that.
Yep.
At that point, they had to cut you off because people are listening in the
Yeah.
courtroom or a Zoom call. So now all you do, you're thinking correctly, just follow it up. You got motion for discovery coming. You need a writ of injunction, right? You need that?
Yes, sir. I
Okay.
mean, yes, chief.
All right. And then you're going to wait 30 to 45 days for them to respond to it, which they won't. And then you follow that up with a demand for dismissal. And that's it.
Okay, so the motion for dismissal comes later.
That's the very last thing when they haven't given you this kind of-
Oh, okay, perfect. All right, so hold on. Well, I'm gonna see this. There's gonna be the writ. All right, that's all, and I appreciate it. And tell me that wasn't hilarious in that video.
Oh, it was very funny.
Oh my God. All right, thank you. I'm done right now, but Shayna had sent the question. I put it in the chat. I
Okay.
couldn't answer it honestly. So if you have time, please look at that. I appreciate you, brother. Enjoy your Saturday. Take care.
All right, thank you. And I'll look
Bye.
at it. Nancy, if you could do me a favor and try to track down that comment by Shayna and see if we can read it. All right, we're going to Lisa. Lisa Pizzella, how are you?
Hi. Can you hear me?
Yes, I can. Hi.
Okay, cool. I think I'm in the junior or senior class. I can't remember which one. But I'm asking about the declaration of trust. At the bottom, it says the address. Do I use my home address or my postal address at the very bottom?
The very bottom is the proof of service page. So I would definitely want you to use your postal address.
Okay. Okay. And then one more quick question on putting your assets in there. How do you do things like that doesn't have serial numbers like gold and silver and stuff like that don't have, you don't have a whatever number?
Well, if it's gold and silver, then you can just use the periodic table symbols for it, AG or AU, and then reference the ounces that you have. That's really all you need to do. Just don't say the location of where it's held.
Right. But what if it's not gold and silver, just like any other thing that doesn't have like it's not a piece of equipment or just, whatever else, I don't know, stuff that you want that's valuable, but doesn't have like some kind of number on it or something.
Right. Try to describe it as best you can.
Mm-hmm.
And then, just state who is going to be the holder of that asset, which is your trustee or an authorized representative that your trustee hired to hold it. And remember, do not share the location where it's being held. Just say it is a warehouse receipt. So you can create a warehouse receipt describing the items, but you don't state where it's actually being warehoused. Okay.
Okay.
That's what you got to do.
Okay, cool. Thank you.
You're welcome. All right, going to Nathaniel. I hear you say you are the new guy. How are you? All you got to do is unmute your mic, Nathaniel Burgess.
Yes, this is Nathaniel.
All right, cool.
Yes, I am a freshman, and my purpose or reason for joining is because I wanted to know how to basically defend myself and in court if I ever needed to. But my two reasons is one, I have child support, and it's closed as far as credit reports. It's not even on my credit report. I've had it taken off. But because of that child support, I can't get a passport, and I'm in business, and I need to travel, and I can't. I have sent out for my certificate of live birth, and that's pretty much where I'm at in your course. I'm very new. I know what your thoughts are on what I could do in terms of the passport or child support even. They're not, nothing's coming at me as far as trying to take any money from me or anything like that. It's pretty much closed. However, I'm sure the debt is still there somewhere. And my real question, and I'll shoot you real quick, is that I wanted to know, is there any processes that have changed in authenticating my birth certificate? Because that's my intent. Authenticate my birth certificate, get my express trust, and get a 98 EIN for and that's my question.
All right, great questions. The process with birth certificate authentication has yet to change. It is still the same. You will authenticate on the state level first. That depends if your birth certificate is established by the county public officer, such as a physician. If it is, then you need to go down to the county first and do what's called exemplification. If not, then you go directly to the state. From there, the state will return it to you and give it to, the next thing you have to do is give it to the U.S. Department of State.
Okay, well, I'm in Georgia. Okay, however, I'm a Hoosier national.
That's fine. You got to send it to Indiana.
So I went to Vital Check, and I went through Vital Check, and they've sent it to Indiana. So I haven't received my birth certificate yet. I'm still waiting, actually. When I received them, I was going to, when I received them, then I was going to send them back to Indiana to the Department of State or State Secretary of State. I'm not sure which one it is. Once they authenticated, I was going to do send it to Virginia or the federal level.
Right.
Okay. Once I get that back, then I was going to do the affidavit.
Correct.
Okay. Now after that, what's next for me?
After that is the steps within the sophomore class. You start to get into the entity reclassification process.
Awesome. Okay. Well, we'll just stay at the freshman level, and I'll just keep on listening to you vets. Thank you very much.
No problem. And I have yet to do a child support webinar to upload in Patreon. I'll do that as well. In regards to the question that you had for the passport, if the amount cannot be paid, and I would only suggest paying it if you have an emergency travel visit, right? Well, if you have an emergency travel visit, then just go ahead and pay it and be done with it. But if you don't have anything like that, and you're just trying to travel for recreation, fun, and you have some time to negotiate this thing or battle it out, then you definitely want to do a tax restraining order, a tax injunction. That information is available to you inside of Patreon, and you can watch that and put together your form of a tax injunction and send it out to the IRS and all of the associating parties to get you on what's called the do not tax list. Okay.
Okay. So would you consider child support taxation?
Yes, I do. It's slavery.
Okay. Title IV. The amount that it is, it's, saying it's like $100,000. It's, and it's beyond what I could actually go to pay. And so right now I'm just trying to figure out my best recourse. I know that it's not legal. I know that it's voluntary. I understand these different facts, and so I'm just asking general right now. I'm going step by step, birth certificate first, and then and I will consult you. I will pay you the consultation. I have no problem with that. But is that your answer, that I should do a tax injunction?
I misunderstood. So it is, your passport is being rejected for the child support amount. Okay. What you want to do is go and get all of the orders that is against you with the state when it comes to child support. Get every single one. Every single order must be denied. Every single order must be denied separately. Affidavit of denial, ... judgment of, whatever they call it, and deny everything in those orders, point for point, line by line, word for word, paragraph by paragraph, all the way down, and end it with a proof of service that you sent it to the clerk of court and the child support agency. Do that for each one first. After that, you're going to submit a motion for discovery. You need to have presented to you by the state how you have an agreement to pay the woman anything. Both of you came together a long time ago to take care of a child. The state does not need to come in and act as the guardian over that child or act as the father for that child. They need to give you discovery. A lot of times, in that case, when you do it that way, it doesn't move past discovery. Therefore, you simply move for a dismissal.
How do I get the orders? Where do I call? This would be in Michigan. In Michigan, where would I get those orders from?
From the court. And it's free.
You said it's free?
It's free to you. You go down to the court and you say, I need every single order in this case.
Okay. And the last question is, these webinars that you have that we're doing right now, they're being recorded and we could listen to these later?
Every single Saturday class is recorded, so you can go back and listen to this.
Awesome. Thank you so much. Is it a way that you can tell one of your assistants to send me something to my email so that I can pay for a consultation with you or one of your assistants?
All you have to do is go into Patreon, type in the search bar, book a consultation, and you'll see all of the links there. And I advise that you click on each one of them so that way it tells you what is the earliest time frame that's available.
Thank you so much. Thank you.
You're welcome. No problem. All right. One of our reps, Isaiah, told me the question here from Shayna. She was given a certificate of trust from a bank to fill out. They wouldn't accept hers that was taught to us. Page 2, they're asking her if she is the grantor. All right, so if you put in your certificate of trust, you can list yourself as the grantor and you can list yourself as the trustee. That's the only two parties that you have to reveal when it comes to your trust enterprise. Or you can have your foreign trustee of the Foreign Express Trust be the grantor in the trust enterprise and still have yourself as the trustee to handle opening up that bank account. If they're giving you a form, you can just simply transfer the information that I've given you onto their paper. It doesn't matter. The most important thing on our page 2 of the certificate of trust, where it talks about how title is being taken, you need to take that paragraph and put it onto theirs. That's very important. Once you do that, they should have no problem. I'm actually surprised that they're giving you the form when really they should just be typing it in themselves. So, but that's how you would handle that. All right, we're going to Jay Prater. How you doing?
Can you hear me?
Yes.
Great, great. How you doing today, Avery?
Well, thank you.
All right, no, I'm good to the class too. I had a conversation with your executive assistant, and it was on the injunction. And I haven't noticed anybody in the state of Alabama that's doing the injunction. And the one that you have listed is from 1835 of Texas, which is pretty much laid out like Georgia and Ohio is, has a lot of information in it. Well, over in the state of Alabama, their constitution is very like one-liner status. Is that going to make a great difference? Because the one to go with, well, they have a few. You said make sure it's before 1933.
Right.
Well, Alabama, they're only, well, the last one is 1901. And this is when certain people were kind of like blocked out of their land, if you know what I mean. And they have a few prior to that. Do I need to go back prior? Because all of them really don't give no information like what's in Texas. They're all pretty much one-liners from the beginning of 1819.
Well, we've done it in Alabama, and yeah, we've used 1819.
So just go ahead and use the Constitution of 1901 or 1819?
1819.
Okay, see, okay, all right, help us out now. Okay, I'm good now. I mean, I was sweating bullets, man, for a minute because I was thinking I was gonna have to kind of like add some styrofoam information to it to kind of make it seem full, because technically the way it's set up, this is pretty much a one-page document when I get done with it. I mean, really, it's one page, and I can almost get the, if I want to, I can almost get the notary at the bottom.
Right.
So just wanted to know that. So 1819 is the one to use, correct?
1819, and we always use information coming out of the American Jurisprudence's books that deals directly with injunctions. That's what we do. So if you guys get a copy of the AmJur for, I'd recommend 42, version 42, which dealing with infants and inspection laws. Get a copy of that, and you want to go into like page 300. That's where they have all of your proven case laws, how injunctions work. And that's what's going to get the sheriffs and all of the courts to enforce your injunction.
They're not gonna come and pay me one of them old good old boy visits, are they?
No.
Nah, okay.
They used to do that, but they don't do that anymore. And usually why they did that was just to see if you're not some form of terrorist trying to, take advantage of the system.
Okay, so I'm from Michigan and born from New York, and coming down here, this is like a whole nother land, and they do things different. I just want to stay compliant. That's all.
Right.
All right, so okay. All right, so I appreciate you.
All right, thank you.
All right, thank you. So,
all right.
1819. Oh.
Let's see. Now we're going to Serge.
Hi, Avery. Can you hear me loud and clear?
Loud and clear.
All right, perfect. So I have one simple question, and it's about the Barbie Treaty and the Sultan of Morocco. So I'm in the complete course, and I was watching your latest videos, and I don't fully comprehend who or what is the Sultan of Morocco and how we pledge allegiance to the Sultan of Morocco and also British America. Can you please clearly define who or what is the Sultan of Morocco? That's it.
Okay. I can't say who his name is, but we know that the title exists, and we know what he can and can't do. But the Sultan is the cream of the crop over the entire earth when it comes to land masses. And he's given plenipotentiary power over to other kings and queens and even presidents. You have already pledged your allegiance to him because your name was considered a sub-corporation under the main United States of America Corporation, which started as the British of America Corporation. And that is only in existence by permission of the Empire of Morocco. I'm not talking about the state of Morocco over in Africa continent. I'm talking about the empire, which covers a vast wide of land masses. You're already covered under him because you're a sub-corporation of the United States. Should I say your social security, birth certificate, person is under the United States of America. Now, you have an out, which is your trust controlling those entities. and your trust is backed by those treaties that the Sultan has instituted for you, such as Treaty of Marrakesh. Treaty of Marrakesh is what began this entire thing for the United States of America. It's what gave them the power to start doing the Articles of Association, then the Declaration of Independence, then the Articles of Confederation, then the 1787 Constitution of the United States. So that's the flow chart, that's the order of it. His exact name, I can't tell you. I can't tell you his exact name, but there is the Empire of Morocco. Very good question, though. Gonna go to Lynn. How are you, Lynn? All you gotta do is unmute your mic, and we can hear you. Going once, going twice? No?
I'm sorry. I was trying to push the phone there to get it off mute. So can you hear me now?
Yes, okay.
Thank you for taking my call. This is Lynn. I'm a private client, and I just wanted to ask, what if the hospital that you were born in is closed?
It doesn't matter. It was in full operation back then, right? So you can still use that address. Are you saying that address right there is no longer a hospital?
Right.
Okay. Do you know where they moved?
No, I do not.
Okay.
Nope.
Do you still live in the same county or area?
Yeah, no, I don't.
Different state?
Uh-huh.
Okay. Your rep is going to handle that anyway, but
okay,
how I would do it is this. Yeah, I'll pull it up here. Situations like that where the hospital is no longer in operation, I would go, let me see. For example, so what your affidavit of domicile, what it's going to say is such and such who being first duly sworn under oath deposes and says that the affiant resides in and maintains a place of abode in the city of, that's where you put the city where you were born.
Okay.
You put the city. And then the
Okay.
county of, go ahead and put that county where you were born. Then it says state of, and then you put the state where you were born.
Great.
Which he or she recognizes and intends to maintain as his or her permanent home. This is what you call the home rule. It is an actual act, the home rule. Where your social security or birth certificate came out of, it will never, ever change, no matter how many times you move across the world. Your commercial avatar starts there. That's the home rule. So it's okay for us to say that this person on the birth certificate, that's the permanent home. Followed by, affiant declares that he, she also maintains a residence at, now this is the tricky part. I always want you guys to use the county office where that birth certificate came from. So if you don't live in the same county where you're filing this information, then you're fine. You can list the county right there. Because once the county receives it, they're not going to say, hey, I work here. You can't use this. Right?
Uh-huh.
That's all you got to do.
Okay. Thank you so much.
You're welcome.
Thanks.
All right, we're going to Robert. How you doing, Robert? Just got to unmute your mic there and you'll be good to go so we can hear you. Robert, going once, going twice, going thrice. All right, I'm gonna go ahead and go to Ryan. How you doing, Ryan?
Real good, Avery. How are you doing?
I'm well, thank you. Thank you so much.
Thank you so much, Avery. I have a tax liability with the IRS from back in 2014. And it had been, first of all, I had requested a I guess a supervisor to review that with the IRS, and they never responded to that request, and they sent that debt to a collection agency. And I want to say that was maybe late 2016. And I ignored the collection company for, well, forever. And they never ever tried to call. They would just repeatedly send a statement showing additional interest every time they would send one, and then the balance due. And just the other day, within the last week, I received a letter from that collection agency that they had essentially given up on the debt and that they're going to send it back to the IRS. And I just have some concerns about how to handle that if the IRS comes back around trying to collect that. And the concerns or the questions I have are, now that I'm established with the trust and have my trust set up, what do you predict they might do, and how would you potentially handle that?
Well, as always, they're probably going to try to secure a lien, a federal lien, on your existing properties and the business names or your name. So the best thing to do is quick claim all that stuff over into the trust. That way they can't find anything. But you are, what I'm going to do for you is I want you to send me over those recent letters and anything that you have from the IRS, so we can go ahead and send out your tax injunction. All right, that's going to be on me.
Great. I appreciate that, Avery. And I'll get a meeting booked with you here sometime in the near future too, and just get caught up. I haven't spoke to you in a while. So thanks for everything.
You're welcome. No problem.
Take care.
Take care. Look forward to speaking with you very, very soon.
Likewise, Avery. Take care.
All right. All right. So you had some issues with the mic, Robert. I'm going to go ahead and go back to you. Let's see.
Hey, can you hear me now?
Yeah. Thank you. Gotcha.
I appreciate you, sir. I just joined a couple of days ago. I got pretty much through the senior class videos, but still consider myself a new freshman. Just gotta go back and obviously execute on all the great information you put out. So I did my ABC and my injunction already. Shout out to Jay, who's in here. You were on our book club a couple months ago.
Awesome.
Yeah, and so I was able to get a head start there. So I'm in the process of trying to designate a foreign trustee to obtain my 98 number. But in some of the previous videos, you mentioned that we could file exempt while we're setting up our trust. And then in different videos, you said to wait until we get our I believe our trust account set up. And so I just wanted to clarify if we were able to do that. Sorry, just for context, as a W-2 employee, to file exempt before the trust is in place.
Right. You at least want to have your trust enterprise and its associating bank account set up. So that way, when you update your W-4 and file exempt, you can provide your human resource with a voided check that's connected to that trust enterprise, and now they have a location to make the deposits. You want all of your monies that you're claiming to not be withheld to go directly to the trust enterprise. So that way the trust enterprise can handle the tax filings at the end of the year, dollar for dollar. Still there? Good to go. Mic went out. Yeah, I think it went out. Okay. You couldn't mute. So I hope that answered your question. You want to get your trust enterprise bank account open first before you update your W-4. So that way there's a proper accounting of where the money is going. All right. So let's go to Terrence. Just unmute your mic. How's it going?
Hey, how you doing? Can you hear me?
Good. Yes, thank you.
Yeah, I'm a complete zero member. I've been studying this for like the last 2 months, so I'm kind of in between tiers here, waiting on information, and I've gotten some things done.
Okay.
But I have a question, could be kind of complicated. If it's too complicated to ask, then I would like to do a consultation. I'm living in Maryland, probably one of the worst places to actually do this process. Maryland is the only state among the 50 states that does estate and inheritance taxes. So my question is, I called the land records because I want to record my trust, and I can't do it unless I have a deed. I don't have any property in Maryland, but my father does. He owns his house free and clear. He doesn't have a mortgage. He's already paid off, and he's actually leaving me the house in his will. Now I was in the process of setting up, prior to me doing this process, I was in the process of converting his will into a trust, just a regular living trust, so he could avoid probate. Something was to happen to him, but I stopped. Just trying to figure out now, since he's going to leave me the house anyway, me and my brother, do I need to get put on his deed and then record it that way, or just, I don't know. I'm trying to figure out what to do, because again, I thought about even bringing him through this process, but I think he's too old. He's not going to want to do all this, but just trying to figure out somehow how I can use his property to, be able to record my trust. That's just the first question. You can assist me with that.
Yeah. Simply just do a quitclaim deed from him to you. And from there, you'll have the opportunity to do another quitclaim deed from yourself to your trust.
Okay, so the quitclaim deed, like, what is that taking the property from him? Because again, he's not going to, I guess, transfer. Ownership is not going to transfer to me until he passes. So, like, what exactly is the quitclaim deed doing?
Yeah, it's transferring the property from him to you right now, 100%. If he's not ready to do that, then you're going to have to go a different route and getting your trust recorded much sooner. So Maryland is an issue, and they're only wanting you to do these things if there's an actual house represented by some type of deed or promissory note. So I would recommend that you just go to a better jurisdiction. Go to Georgia, go to Florida, and do it there. You don't have to have property. I've taught that in the beginning, you have to have something in the trust to fund it. And when I first did it in California, it was just the physical, tangible assets that I had. They did fight me on that. And then I said, okay, fine, well, I'll go ahead and put up some property in there, a real house. And then I got it done. Trying to do it again in other places. Now they're saying, no, we can't do it with a house. And most of you guys are having that same issue where the house is not enough because they know the type of remedy that you're going to get out of this. Now, the one thing that they cannot refute is a bond, a business service bond. You guys can go to suretydirectbonds.com and acquire a bond and attach that to your trust and record it in the county office as an actual, sometimes they call it an agreement, sometimes they call it a contract, or they just call it a bond. And you can get it recorded in that way. That information was going to be shared inside of version 2 of the course. So that way you guys have a fail-proof way of recording.
So that would even work in Maryland, or would you recommend just using that in another state?
It might work in Maryland. I haven't tested it in Maryland or Virginia, but I think it would.
Okay. And my last question, on part 2 of the checklist, it says record items 1 through 6. So it's the non-UCC, the declaration of trust, the trustee minutes, the powers and duties, whole harmless agreement, and plenipotentiary contract. So all of that gets recorded at the same time. That would be the first thing that I would actually get recorded with the county.
Yeah.
All of those documents.
Yeah, try that first. And if they give you any pushback, then you may need to separate some of those filings, meaning you may need to file the non-UCC by itself. And then you come back in and file the declaration of trust with the business bond and all of its other attachments with it separate.
Okay. Okay, great. And when do you think you would have, I guess, the phase 2 together with the bond and information?
It's almost done. It's almost done. I'd say before the end of the month.
Okay, great. FYI, I called yesterday to get my 98 number. they kind of went off the script. They don't go by like saying box 1, box 2, box 3. They were just asking questions randomly.
Right.
And they asked the question of what you said, what country is the trust originating in? It kind of threw me off for a second. And I just told them the name of the country. And but they did not ask me like all the other questions. Like I didn't have to. I was actually volunteering information. I said, well, what about box 10 or what about box 9?
Right.
And
Sometimes we get ourselves in trouble by doing
yeah,
that.
yeah.
Just take what they give you and move on.
Yeah, and so but I was able to get the number. It worked out.
Okay, good.
Thanks a lot. Appreciate the information. You're definitely doing a great work.
You're welcome. Thank you. All right. All right, we got time for one more, and then we have to go. That's going to be James. James Saunders, how you doing?
Hey, what's up, Avery?
Hey, I'm doing good.
I've been trying to get a hold of you for the longest because I have something that will streamline a process you've been working on and will greatly help you get with me. I think you'll be pleasantly surprised at the idea that I had. The other thing I wanted to bring to your attention was me and a few other people were trying to get this SBA loan situation taken care of. So that was the only other thing I want to bring up.
All right. Are you
I
on
know
my
you have a process.
Are you on my my schedule coming up?
I don't know. I've been trying to get a conference with you. I told Nancy, but I haven't physically made a set an appointment yet. I've been running around doing all kinds of stuff, so I do apologize.
All right. If you can get one with me, sometimes I'm able to move you guys up depending on how I get these previous consultations done. So please just book it anyway. It might say March, but I may be able to move you guys up.
They messed up DWs around. Okay. But what I was talking about, I know that this route, it has to do with your book or whatever. And I know one route you haven't been able to get that taken care of, and I wanted to help you with it. Because I'm very skilled in that area anyway. I do spoken word and all kinds of stuff. So I'll get with you about it. But that's all it was, just that and the SBA. Everything else, you guys have helped me with more than anything. And I've been talking to Nancy. I've been emailing back and forth with Jay. There was a misspelling on my middle name for my injunction, but I already emailed Jay about that. Hopefully he'll get back to me pretty soon so I can get those sent out.
Okay. All right. All right. Well, I'll wait for you to book some time.
Okay. That's all I really needed, Avery. Thank you so much.
All right. Thank you, James.
Yep.
I'm going to take one more. We have, that was a short call. So let's go into Shamina. Shamina, just unmute your mic, stay with tier you're in and ask the question.
Avery. How you doing? I'm in the freshman tier still.
Okay. All right.
So the question I wanted to ask you was, so I have some unpaid tolls from Miami-Dade and they're in collection. So I was wondering, how could I avoid paying them? Just to be honest, do you use the Accord of Satisfaction to do that?
I'm sorry, you said what type of account?
No, I have unpaid tolls, like, like from your license plate.
Yeah.
Yes. So I was wondering how to avoid paying them. Can you use the Accord of Satisfaction?
I've never done it for that. I usually just pay those. I recommend just pay them. In Florida with the Sun Pass and all those, I would recommend just pay them. They are going to give you a runaround because I tried to do it in California and it's just not worth the fight.
Wow.
It really is. It's not worth the fight. And they're gonna really string you out for a long, long time. Now you can try it. You can try it according to satisfaction. You can try Treasury gift checks using the Treasury EIN numbers. You could try it, but I probably wouldn't bank on it. Here's why. Because there is no original contract that you had with the toll company. You accepted going through that specific section. That's why. And there was no taking your instrument or taking your social security number to defraud you or in any kind of way. It was, we willfully went through it. We accepted tolls as we did it. So I would say just pay it.
Oh, wow. Okay. And I have one more question for you. I watched the video like a while back, like a month or two back, and when you were talking about filling out the form to change your business address for iPostal, and there was a certain way you had to fill it out, and you had to use the appellation name instead of your name. So what I did was incorrect. I put my name on it, right?
No. You can use
And I did not check the thing at the top that says tax exempt. I didn't check it, but I used my 88 EIN number. So I'm wondering if that is an issue.
You're talking about the form that allows this location to receive your mail on your behalf.
Yeah. Mm-hmm.
It's 1535 form. You want to give your actual real name. You want to give because you're giving them the actual ID that goes along with it.
No, not that one. Not that one. I'm sorry, Avery, not that one. It's the 8832.
8832 form. You're doing
88.
reclassification. Okay. All right. So yes, you have to give the exact name that you've given on the IRS website to get that number, the exact spelling, put the 88 number that's in the EIN, put that there. As far as filling out each question on there, do you think you did that right?
No.
Okay.
So I'm gonna have to do it. I'm gonna have to do it over.
Yeah, you may just do it over or just grab a quick consultation with us and we'll do a Zoom call and show you our screen and show you exactly how it's supposed to look.
Okay.
Okay. You want to do that for the estate, the enterprise, any LLCs and corporations you have, and that is it.
All righty.
Okay.
Thank you.
All right, you guys, this was recorded and it will be uploaded into Patreon a little bit later on today. I thank you all for coming in. My executive assistant, Nancy, just wants me to quickly explain the difference between a Patreon member and a private client. Most people believe that if you become a Patreon member by joining freshman, sophomore, junior, or senior, or the complete tier, that it automatically comes with a free consultation. It does not. You will have to purchase the time to speak with myself if it's a court case. I only do court cases only, but if it's anything else, according to the course, you will be assigned to one of our reps and they will handle your call efficiently. If there's something in that call that they cannot answer, they will get it to me and then I will get you the answer directly after. A private client is someone who feels that they don't have necessarily the time to go through the class or the courses and do the legwork themselves, where they agree to go into an agreement with us, actual agreement where you are the contractor and we are the contractee, and we do everything for you based on the information you've provided us in the application. You get one free monthly call with your rep for 1 hour. And as I just said today, every 15th of the month, there will be a group private client power call where we get on and discuss anything further. All right, so that's the difference between a private member and a private client. If you are a private client and you've received your monthly free 1 hour call, and you've also done the power call on the 15th and still have questions, you have to purchase time to speak with myself if it is a court case or one of the reps, okay? We have to be very honorable with everybody's time so that way it's fair to get you the expected and required information that your unique situation deserves, okay? So with that being said, that's going to be it for today, and I'll see you guys next Saturday, where we will continue talking about discharge, and I enjoy speaking with you all. Thank you. See you all next time.